Good morning. How is everyone today?
Doing well, thank you.
Morning, doing well.
Is everyone participating today? Is everyone participating in takedown?
Oh, yes, yes.
Okay.
Morning, Council.
Morning, Judge.
Morning.
You may see an interesting background. I'm actually working from home today. So you've got the bird's eye view of my basement office. I do not see Mr. Townsend on, and he should be on this call, but he is in the office. So let me just check and make sure that he can get on, and then I'll come right back.
Okay.
All right, I believe we have Mr. Townsend on now.
Yep.
All right. So we are here in the matter of Ameris Bank and Ameris Bancorp versus William J. Villari et al. On defendant's motion for summary judgment. I'm prepared to hear argument. I will tell you that I have read the papers, and for me, I will tell you my impression, the real focus of the argument is to whether whether there's a question of fact as to whether Mr. Villari or the trust suffered an adverse effect. I think that issue will ultimately determine for me whether summary judgment is warranted or not, if there's a question of fact on that issue. So you can tell me anything you want me to know, but I just want to give you the heads up in advance that that's where I'm focusing. So I will turn it over to Mr. Kushner. Are you going to argue this?
Yes, Your Honor.
All right, go ahead.
Thank you, and I appreciate you letting us know you read it and that you're focused on a particular issue. Frankly, a lot of ink has been spilled, a lot of trees have been killed in the disputes between Ameris and Mr. Villari. I think this is one of, I don't know, half a dozen disputes that has arisen out of their prior employment relationship. And this is just sort of one piece of the puzzle, but it is a discrete piece. And just sort of a little bit of background, you may have gotten this from the pleadings, but it can be a little confusing. So Mr. Villari, a long time ago, created this U.S. Premium Finance Holdings Company, which owned intangible assets, largely goodwill, relationships with insurance agents. And as the name implies, the company literally finances insurance premiums. So King and Spalding gets malpractice coverage. Their premium is $1 million. Rather than stroke a check for $1 million, companies like USPF finance the premium. Okay, it's actually a really good business, but that be that as it may. So what Mr. Villari was able to do was work with banks who provided the employees and the funding for these loans. So Mr. Villari, neither individually nor through USPF Holdings Company, originated, validated, or owned any loans. They basically provided the goodwill, the intangible assets associated with the U.S. Premium Finance business, which was used, licensed to a bank. And Ameris is just one of several banks that Mr. Villari has done this with. And as you may have realized, there was a prior relationship with Brand, and it was moved over to Ameris.
So what is, in this relationship, what duties does Mr. Villari perform specifically in this relationship?
Well, so there are different relationships, okay? So there's an MLA, a license agreement between the bank and USPF Holding Company and Mr. Villari, where they license the goodwill and the relationships to the bank. The bank hires Mr. Villari as an employee to be the president of the bank's division. So it literally is called U.S. Premium Finance, a division of bank. Mr. Villari is the president of the division and an employee of the bank. And he gets paid through the license agreement as the president. In this case, he also became an employee because the bank bought the holding company. So the holding company gets a license fee for licensing its intangible assets. The bank does all of the underwriting, the validating, and the funding of the loans. And the bank gets all the money from the loans. Now, the proceeds are split pursuant to the license agreement, but it's the bank's assets that are at issue. It's the bank's money to fund the loans and the bank's loans. So what we have here is in 2016, Mr. Villari moved from Brand Banking Company to Ameris. They refer to it as bolting on. So the division unbolted from Brand and bolted onto Ameris. So all of the U.S. Premium Finance, a division of Brand Banking employees, became employees of Ameris. So literally they were in an office, they took down the Brand Banking sign, put up the Ameris sign, and now they're all employees of Ameris. And Ameris bought the loans, the outstanding loans from Brand. Okay, and Brand made whatever represent warranties about the loans. Ameris did whatever due diligence it wanted to do, but it now owned all those loans and originated, validated, and funded every new loan after December 15th, 2016. As part of that transaction, Ameris also bought some of the shares in holding company. And then it was actually, I think, in 3 tranches, and the final tranches, the second and third, were done in January of 2018. And the agreement that we're talking about here is dated January 25th, 2018, and it's Ameris purchasing the remaining shares in holding company from the 2 shareholders, Mr. Villari and the family trust. And the agreement is clear and plain on its face. There's no ambiguity. There's nothing to interpret. Ameris wants to bring in a whole bunch of other related tangential stuff, but the agreement stands on its own. And what they want to say is Ameris had some bad assets that may result in losses that were not on the financial books and records of holdings, but that Mr. Villari should have disclosed to them as part of this transaction. But it is very clear in the agreement, including in the adverse effect provision, that it's limited to USPF Holding Company. And as Ameris admits, these loans, the bad loans they're talking about, A, were originated by Brand and purchased by Ameris, and were on Ameris's books and records. We've cited to the testimony of Ameris's chief executive officer and chief financial officer, both of whom admitted that all of the loans at issue were on Ameris's books. So the reps and warranties in the SPA, the stock purchase agreement, all relate to holdings and Mr. Villari and the trust's interest in holdings. Now, if Ameris takes a loss on those loans, it has nothing to do with holdings. They're not assets of holdings. There's no material adverse effect on holdings. In fact, if the loss had been taken at any time, it wouldn't have affected the purchase price. The purchase price is set in the agreement. There's nothing ambiguous about it.
Would the problems with the loans have had an adverse effect on Mr. Villari or the trust?
In the future, possibly. Because there's an earn-out provision where the payments relate to the profitability of the division. So if the division takes losses, obviously its profitability would be less, and then the earn-out would be less. But in terms of a material effect on them in connection with the sale of their shares of holdings, no. And in fact, in their own evidence, the Razi declaration, they take the position that Mr. Villari didn't even know until January 31st. The agreement was signed on January 25th. So
your argument is that he didn't know before the SPA was signed.
Correct.
And that even if he did know about the bad loans on the books, that was not an adverse effect because it only pertained to, because the warranties he gave only pertained to the holdings.
Correct. And if you look at the definition of adverse effect, section 5.5, and then the definition, it's limited in relationship to such seller's ownership of USPF Holding Company. Those bad loans, if they had an adverse effect on Ameris, were not in relationship to Mr. Villari and the trust's ownership in their shares of USPF Holding Company. Now, if Mr. Villari knew beforehand, would he have had some other duty to disclose? Perhaps, but not in connection with the sale of holdings. But again, their own evidence is he learned from the guy who perpetrated the fraud on January 31st.
All right, so maybe I'm missing something. So I'm looking at the appendix and what the definition of adverse effect is. Clearly, Mr. Villari and the trust are sellers. Correct. So the adverse effect language applies to them.
Right.
And it says adverse effect means with respect to a person, Mr. Villari, any event, occurrence, or change that is materially adverse to the business, assets, properties, financial condition, or results of operations of such person, other than things that are specific events that are carved out.
Right.
So this doesn't seem to limit to just the business operations of holdings. Where is that limitation?
That is actually in section 5.5. Absence of certain events. Since January 18th, 2017, except as otherwise set forth in this agreement, neither USPF or any USPF subsidiary, and we're talking solely about holdings, nor either seller in relationship to such seller's ownership of holdings has suffered an adverse effect. So the limitation is in 5.5, in relationship to such seller's ownership of holdings.
So then I go back to, if you've got a company whose goodwill, whose value rests on good stewardship and management of loans, and you've got a bunch of fraudulent loans, why doesn't that adversely affect the holding company?
Because you're talking about two different companies. So the holdings had relationships with agents. Okay, Ameris was responsible for the stewardship of the loans, not holdings. Holdings had no involvement in the loans.
Right, but holdings holds the intellectual property, is that right?
Right, the name and relationships with agents.
Right, so if you're using the name, and the intellectual property has value, and a bunch of bad publicity comes out, or folks get indicted, and that business, that name takes a hit, isn't that adverse?
It could be if it was known at the time, but the facts are that they weren't known at the time, and it wouldn't. If something may happen in the future, they don't know that the loans are uncollectible. In fact, the testimony is they tried to collect them, so that they weren't written off because they tried to collect them, and the bank suffered no adverse effect. They weren't indicted. They had bad loans. I mean, banks have bad loans all the time. So the issue, so it's not whether the bank's loans originated and funded by the bank were bad, don't impact holdings. I understand what you're saying, that if they own the name and they're licensing the name, there may be some negative consequences associated with the name, but A, it wasn't known on January 25th, and B, holdings had no adverse effect. So even if at some point way down the road that they didn't even know about, there might be some negative consequences to the name, it wasn't known on January 25th, and it doesn't adversely affect holdings. It's not on these bad loans. I mean, they're not claiming damage to reputation. Ameris is not claiming that. They're claiming we suffered a monetary loss for loans on Ameris' books. And you should have told us if you knew that our own asset was bad when you're making representations about holdings. And the loans weren't owned by holdings. They weren't on their Ameris has not presented the financial books and records of holdings to suggest that they had bad assets. The cases they cite to, the Hodges versus Med Assets and the NIP versus Checkpoint, which is an unreported Northern District case, those are the actual seller selling the business, and the businesses had either lost customers or had other adverse effects. The adverse effect was suffered by Ameris, if there was one, not holdings. And there's nothing ambiguous about the agreement in that respect, about what they were making representations about, holdings. And again, the only evidence in the record, which Ameris relied on, Ameris provided, is that Mr. Villari was told by the fraudster, by Mr. Dunoff, on January 31st, after execution of the agreement. That right there is sufficient to grant our motion for summary judgment, that it couldn't have been a misrepresentation if he didn't learn about it until afterwards. Even if it even qualified, and we contend that it didn't qualify. Because even if the loans were bad, it's not an adverse effect on holdings and not a misrepresentation about any of the status of holdings. It's financial books and records. I mean, there's a whole list that they claim was breached. The financial statements, it wouldn't be on holdings financial statements. It's not on holdings books and records. It's not on holdings balance sheet. This is 5.8, 5.8A, 5.8B, 5.9. And there was nothing untrue in any of those records, which is 5.16. And as of January 25th, holdings hadn't suffered any adverse effect, nor had Mr. Villari.
All right. Anything else you have for me?
No, Your Honor, it's all, I think it's pretty well briefed. You've read it. You obviously have focused on an issue. Unless you have any more questions, I'll reserve anything for rebuttal.
All right. Let's hear from plaintiff side.
All right, thank you, Your Honor. May it please the court. Robert Thomas with Anderson, Tate & Carr. I'm joined here with Tom Tate, who's a partner of mine with Anderson, Tate & Carr. You can also see Benjamin Razzie is also participating via Zoom.
Judge.
I believe that Mariana Jackson is also participating potentially by phone, although I don't see her right now. Your Honor, obviously we disagree with the defendants on a fundamental point. I think perhaps the most important with respect to the questions that you were asking is that USPF did suffer an adverse effect. And the reason they suffered an adverse effect is that the parties agreed to a value in which they used to purchase, which Ameris used to purchase USPF Holding Company, that was related to the performance of the division. In other words, the revenues that were generated through the use of the intellectual property that was owned by the holding company. And whereas here, some of those loans turned out to be fraudulent, if the value of the holding company is premised on those loans, it has an effect on that value. And so USPF has, as a result, suffered an adverse effect. And I think that the best way to show why that's the case is to take a little bit of a deeper dive into the relationships so that we understand the fundamentals of the relationships and what's actually going on here. I've got a PowerPoint if the court would not mind me sharing my screen at this point.
I will allow it.
Great.
You should be able to share now.
All right. Okay. Can the court see the PowerPoint, the title screen?
Yes.
All right. Well, I guess first where I would start is that U.S. Premium Finance, this is the brand, and this is obviously a case of representations that were made in the SPA about during Ameris Bank's acquisition of this brand, U.S. Premium Finance. And as Mr. Kushner indicated, this brand is over 20 years old, and for the majority of its life, it was owned through USPF Holding Company until it was acquired by Ameris in the SPA. But I think the critical component, and Mr. Kushner alluded to this, is that USPF Holding Company cannot operate on its own. It has to have a source of funding. And the brand, the business, would be the one that's originating the loans, servicing the loans, things of that nature, but it would be the bank that would be funding the loan. And in return, the bank would receive a preferred and guaranteed rate of return. And over the course of its life, U.S. Premium Finance, through the holding company, would enter into master license agreements with various banks. And that obviously includes Ameris Bank, it includes brand banking for Ameris Bank, Northfield Bank, and other lending institutions. The relationship that matters first is the relationship with Brand Bank. And that relationship was codified in a master license agreement in which USPF Holding Company licensed their intellectual property to Brand Bank, and Brand Bank then ran the business through a division within Brand Bank. It used the license to run the USPF business, the intellectual property, through its own division. Now, what's important is that Villari ran that division. He was an employee of Brand Bank running that division. And in 2016, after 13 years, Brand tells William Villari, we want to get out of this industry. The MLA allowed Villari at that point to take USPF to a new bank to find a new loan source. And it permitted the new bank to purchase that loan portfolio. And so Mr. Villari took the idea to Ameris Bank, and in December 15th of 2016, Ameris Bank, USPF Holding Company, and William Villari entered into the master license agreement. This is the first relationship between the parties. Ameris is now the licensor of that intellectual property and that goodwill. The entire division is moved from Brand Bank to Ameris Bank. Ameris establishes U.S. Premium Finance, a division of Ameris Bank, as a division within Ameris. All of the Brand employees move to Ameris, and Villari is hired to act as president and run that division. So in this respect, it substantially mirrors the Brand Bank arrangement. And again, it was executed on December 15th of 2016. Ameris was to receive a preferred rate of return of 2.15%. But one thing that's important here is that under the master license agreement, William Villari bore the risk of any loss of any loans made under the master license agreement. So if there was a problem with loans, Mr. Villari individually bore that risk. Ameris, concurrent with entry into the master license agreement, also entered into an agreement with Brand Bank, where Brand sold the loans that had been generated under the USPF division when it was operating with Brand. It also, in that agreement, agreed to terminate all of the employees that were running that division and allow Ameris to hire those employees. And it also assigned its lease obligation. USPF division, when it was operating under Brand, was operating out of a commercial building located in Norcross, and Brand assigned that lease to Ameris. So the entire division shifted from a Brand Bank to Ameris Bank, and Ameris was now running U.S. Premium Finance as an internal division of Ameris Bank. That relationship lasted for about a year, and until Ameris agreed to purchase all of the stock in USPF Holding Company approximately a year later. And that's the SPA, and that's what we're arguing about today. And the SPA is an agreement between William Villari, as you noted, and the Villari Trust, and Ameris that sells the stock in USPF Holding Company to Ameris. Ameris obviously wanted to buy USPF Holding Company so that it owned all of the stuff that made its division run. The SPA, while it is true that it had an effective date of January 25th, 2018, the closing date was January 31st, 2018. And that becomes important because of a few facts that we're going to talk about later regarding what Mr. Villari knew and when he knew it. So the effective date, January 25th, closing date, January 31st. Now, here's where we get into the meat of why we say there has been an adverse effect on USPF. So the question is, how did the parties value the sale of those assets, the sale of that stock? And the answer is, it was in relation to the division's performance. In other words, in relation to how the division had performed while it was an Ameris division, and how it had performed while it was a Brand division. So they agreed to value USPF Holding Company based on how the division that was licensing USPF's holding company's intellectual property was performing. And that made sense, because how else do you value intangible assets like intellectual property other than by reference to what that intellectual property is able to generate? And so that's what they did. Over the course of the various contracts that permitted Ameris to purchase USPF Holding Company, they paid $83 million, and they value that based on prior revenues.
Let me ask you this question. Was there some sort of formula or rubric, or how do you determine relative to the revenues, earnings, pre-tax or post-tax, how do you convert all that to a number that you say this is the right number?
Right. Well, I guess one way to answer that would be to use Mr. Villari's own words, and this is from a transcript during an arbitration hearing. We'll talk a little bit about the arbitration a little bit down the road. But he indicates that we had essentially established a purchase price of U.S. premium finance before this, right? You can't come up with a purchase price or a number of shares to be paid without having a value. So we did that at the end of the fourth quarter of 2016. We met again just to check and make sure in June, July of 2017 that the numbers were about the same. And here's where he says we were using a $14 million pre-tax number that U.S. premium finance was producing and had done that for the prior year or two. What that formula actually looked like, I don't know in terms of how they applied it by multiples or whatever it is they did to take that $14 million and turn it into a valuation. But that is, in Mr. Villari's own words, them using the division's performance to determine a value of the holding company's assets. And again, and there's been some discussion of this, there's also an earnout value that is tied to the division's future earnings. So there's obviously, like any earnout provision, various thresholds that if met, money then goes again to the sellers. So again, the value of USPF Holding Company was determined by prior performance, the portfolio, and potential future performance of the division. Obviously, we've already had some discussion about the reps and warranties. You know, we read this quite broadly. Neither USPF, it's not just William Villari or the trust, it's has USPF suffered an adverse effect, or has either seller in relationship to their ownership of USPF suffered an adverse effect. And they represented and warranted that neither had. And adverse effect is defined to be quite broad. Any event materially adverse to the business. And again, 5.16 of the SPA is a full disclosure paragraph that says that no representation or warranty by sellers contains any untrue statement of a material fact or omits to state a material fact necessary to make the statements contained therein in light of the circumstances in which they are made, not misleading. So it's not just a duty to tell the truth in your reps and warranties. It's a duty to tell anything and everything you know that might bear upon the accuracy of your reps and warranties. That's what 5.16 does. And it's frankly, I think, intended to avoid what the other side is attempting to argue here on some level. All right, in terms of the facts, with respect to what Mr. Villari knew, and this is critical, in May of 2018, just a few months after the SPA was closed, Ameris learned that some $15 million in loans were potentially not collectible. And they learned that from a USPF employee named Neil Dunoff. And he had indicated that a substantial portion of loans associated with Brandywine Insurance Advisors, LLC, and a few related entities were fraudulent or potentially problematic. And that's not an immaterial number, because $15 million represents the USPF division's entire pre-tax income in the year prior to when Ameris acquired USPF. So Ameris was obviously concerned. They were concerned with the assets they had acquired, but they were also concerned with what the sellers knew and when they knew it. And so they did some investigating. And it turns out that in late 2017 and in early 2018, Mr. Villari had requested certain reports from Scott Mitchell, who was a vice president at USPF, relating to the Brandywine entities. And Scott Mitchell sent him the reports. And the reports revealed that USPF's exposure to Brandywine entity-related loans had increased from $8.6 million in August of 2016 to $24 million by late 2017. And there was concern about that. And Mr. Villari in the arbitration admits that he had received those reports during that time frame. And Mr. Mitchell, during that arbitration, testifies that that was concerning. That was a substantial portion of their portfolio tied up in these entities that we learn are problematic. So that's late 17, early 18, prior to the closing date of the SPA. But there are more and more blatant warning signs. Rob Granite, who is a USPF division's vice president of credit and collections, began investigating the Brandywine related loans in 2017. On January 2nd, 2018, Mr. Granite told Villari of his concern about the loans. He sent to Mr. Villari a report that had found that the Brandywine entities were, quote, quite worthy of an investigation. He sent him that report on January 2nd, 2018. Mr. Villari did not respond. So Mr. Granite goes to Mr. Villari and directly addresses it with Mr. Villari. And this is, again, testimony that was elicited during the arbitration of Mr. Villari. You and Mr. Granite had a discussion, at least one discussion after this episode that we're looking at, right? Yes. And that was on January 2nd, 2018. Yes. And he made clear to you that he had some concerns about this whole situation. Yes. And you asked him, and did you understand that he had concerns that it could be fraud in these files? He had a concern. Yes. Okay. And did you immediately report that concern about suspected fraud to Ameris? No. And did you report Mr. Granite's concern about suspected fraud at any time to Ameris? No. January 2nd, 28 days prior to the closing. Mr. Granite doesn't get any form of a substantive response, so he raises the issue again with Mr. Villari on January 8th and again on January 22nd. Again, no response from Mr. Villari. On January 30th, 2018, Granite tells Villari that the loans were a, quote, DEFCON 5 situation. And this is the testimony from the arbitration. What did you tell him on January 30th? Well, I raised my concerns about Brandywine. And I said, hey, this stuff is no good. This is fraud. You've got to do something about it. You've got to stop it. Nothing is happening. We've run through the motions. There's no more to do is essentially the conversation. I described Brandywine as DEFCON 5 and some of the other agencies as a lesser DEFCON 4. I honestly don't know where DEFCON 5 came from, or who came up with that terminology, but that's what we've been using for this situation. In 2017 and 2018. And so I told Mr. Villari Brandywine was DEFCON 5 and he had to do something about it. He had to stop this from happening. Well, he didn't do anything about it. He didn't stop it from happening. And on the very next day, Mr. Villari executes the SPA and commits himself to the representations and warranties in the SPA. On the very day of the closing, on January 31st, Neil Dunoff, the individual who ultimately ended up telling Ameris Bank about these loans, told William Villari that he thought $15 million of those loans were fraudulent. That's the day of the SPA closing. And Villari did not bring this to Ameris's attention. Again, Rob Granite, in his testimony at the arbitration, got it. Who brought up the topic of Brandywine? Well, Bill brought up the topic of Brandywine. Again, there was some small talk beforehand, but Bill essentially brought up Brandywine. And what did he say? He said to Neil, how many of the loans are fraudulent? And what was Neil's response? All of them. So Villari knew on the day that he executes the SPA that Neil Dunoff considered all of those loans to be fraudulent. This came up in the arbitration hearing. There was an arbitration that was conducted previously concerning allegations by Mr. Villari that he was entitled to additional income under an employment agreement he had with Ameris. And so these issues obviously came up because they were relevant to the employment agreement. And the arbitrator held that Mr. Villari knew about the fraudulent loans and that he should have told Ameris about the fraudulent loans. And in his determination, he held that Mr. Villari's failure to do so was willful misconduct and material breach of fiduciary duty and gross negligence. Specifically, he said, Mr. Villari's testimony establishes that his failure to report the fraud immediately was willful misconduct in that it was intentionally done. Mr. Villari's misconduct constituted a material breach of his fiduciary duty to Ameris and gross negligence. And while I recognize this is not the law of the case, it certainly demonstrates the existence of a material fact about what Mr. Villari knew and when he knew it. Now, Mr. Villari's position and the defendant's position is USPF Holding Company doesn't own the loans, and therefore there was no obligation to disclose, and it's as simple as that. And we consider that to be an incredibly cramped view of the representations and warranties. Again, the defendants represented that they disclosed all events or occurrences that were materially adverse to USPF or the sellers. Ameris was buying USPF. They were buying those intellectual property assets used to generate revenues in the division, and they were entitled to know if there were any issues. So what are the adverse effects? And we've already discussed this on some level, but as to Mr. Villari, at the time he learned about these problematic loans, the MLA was in place. And as I mentioned, and as I demonstrated via testimony, under the MLA, Mr. Villari was responsible for problematic loans made by the division. That was his responsibility. And the MLA was a document that was between USPF Holding Company, Mr. Villari, and Ameris. So in this sense, it is fundamentally an adverse effect as to Mr. Villari in relationship to his ownership of USPF. And this is a transcript demonstrating some testimony that Mr. Villari was in fact responsible for losses or problematic loans under the MLA when he discovered what was going on. And indeed, that's how it played out, because within days after Ameris discovered that there were fraudulent loans at issue, Mr. Villari purchased 15 million of those loans back through an entity called CEBV. So within days, he purchases some of the loans at issue. Now, what about adverse effects on USPF Holding Company? The question is then, just rereading what 5.5 says, was there any event affecting USPF Holding Company's businesses, assets, properties, financial conditions, and business results? And perhaps a better way to frame this question would be to ask it this way. In a deal where the business is admittedly valued by reference to revenues generated by the division using the assets of the holding company, is a failure to disclose that those division results may be overstated due to fraudulent loans the failure to disclose an adverse event? And our position is that the answer to that is a resounding yes. Again, the value of USPF Holding Company was determined in relation to the performance of the division. And if the performance of the division is overstated or at issue, and you know about that, then you know about something that could affect the value of the entity. Again, Ameris paid $83 million for USPF because of the past earnings, the commensurate potential for future earnings in its portfolio. And that revenue generating capability was imperiled. So to summarize, Villari knew of the fraudulent loans before he entered into the SPA. USPF Holding Company was valued in relation to the division's performance. The division's performance was imperiled because of the fraudulent loans, of which Mr. Villari was aware. And the valuation of USPF Holding Company was potentially overstated. That's an adverse effect. Thank you, Your Honor. I can answer any questions you have at this point.
All right, I don't have any other questions. I'll turn it back over to Mr. Kushner. You can have the last word.
Thank you, Your Honor. And just to clear up a couple of things, the CEB.
You can take, I'm sorry, if you can take down your screen, Mr. Thomas.
I'll do it now.
Thank you.
A couple of things, Your Honor. First, CEBV's purchase of the loans is hotly disputed. And in fact, CEBV has sued Ameris for it to repurchase those loans based on the conditions under which they were purchased. So while they want to obliquely reference it as somehow an admission by Mr. Villari, that is not what the facts that came out at the arbitration. That is not accurate based on the allegations of the lawsuit in Florida. That is not an admission, okay? Mr. Villari's testimony, both at the arbitration and the basis for his claim in the suit in Florida, is that he was forced by the CEO and CFO to buy the loans, or they were going to go after him and his family, amongst other things. And it was unknown what had occurred. It came out later that Mr. Dunoff was an active participant in the fraud and had been paid hundreds of thousands of dollars under the table by the borrowers to falsely document some of those Brandywine fraudulent loans, which, by the way, are not at issue in this case, okay? So the issue of CEBV and the purchase loans is irrelevant, okay? Also, I would contend that what Mr. Villari knew and when he knew it is not material. Notably, Ameris has not argued that the contract is ambiguous. There's nothing ambiguous about the contract. We're limited to the four corners of the contract. Nowhere in the contract does it say the value of USPF holding company is based on the performance of the division, and therefore reps and warranties about the division are necessary to validate the purchase price. Not in there. The division is specifically referenced. It's a defined term. If Ameris wanted reps and warranties about the division and the value of the division and the books and records and financial assets of the division, it could have done that. It's a multi-billion-dollar bank. This is not the first time they've entered into a contract. They know how to do this. They chose not to do that. And now, after the fact, they are trying to come back and say, yeah, it doesn't actually say that, but that's kind of what we meant. But you don't get to do that. The contract stands as it's written. And as it is written, Mr. Villari's representations and warranties are limited to holding. Right? So it's very easy to just keep saying USPF, 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 but what we are actually talking about is holding. And nothing about any of the fraudulent loans that were on Ameris's books would have a material adverse effect on holding. Now, if there was some provision in the contract, which many contracts do, that have a 30, 60, or 90-day holdback provision, that if the status of the company as represented, what the value is based on, and if that changes, then the compensation changes. Ameris didn't put that in there. All it says, paragraph 3.1, the aggregate consideration payable by buyer hereunder at the closing for the designated USPF shares shall be $8,921,430 and 830,301 shares. Nothing in there about how they arrived at that. Nothing about what the basis of that is. Nothing about the representations of, no representations or warranties about how that value was determined. It's just set out. Here's what we're paying. And then they said, okay, make representations and warranties about holdings. And these loans, these Brandywine loans they're talking about, which again, not at issue in this case, were not assets or liabilities of holdings, and if they failed, would not affect holdings at all. Would not affect its assets and liabilities, would not affect its books and records, would not affect its financial statements. And this earn-out provision is a red herring, because that is post-closing additional compensation. If the division suffers an adverse effect, the division, and its revenues are down, that affects the earn-out calculation. Mr. Villari gets paid less in the future. So they could have incorporated all of that into the agreement. They chose not to. They specifically limited, and we read it, it's 5.5. They specifically limited an adverse effect in relationship to seller's ownership of USPF. USPF meaning holdings. And nothing about holdings in this agreement is untrue. They haven't alleged anything in here is untrue. Any of the reps and warranties are untrue. They're saying you should have told us about a bad loan held on Ameris's books that you may or may not have known of before January 31st, 2018. That's what they're saying. They're not saying you didn't tell us about something on the books and records of holdings or an adverse effect on holdings. What they're saying is it's not in the contract. It's not in black and white in this unambiguous contract, but we think you should have told us anyway, and now we want you to pay us back. That's not what the contract says. And we are limited under, I think it's 13.2.2, to the four corners of the contract. Not what they wish it said, not what they had hoped it would have said, not thinking back on it, how we might have changed the terms of the contract, knowing what we know now. You don't get to do that. The contract, the interpretation of the contract is limited to what's on the four corners. Parallel evidence, everything Mr. Thomas told you is parallel evidence. And it can't be used to add to, take from, or vary the written contract. And that's exactly what they want you to do. They want you to hold that Mr. Villari, that there was a potential adverse effect on Ameris, and Mr. Villari should have told them if he knew. That's what this comes down to. And that is not what the contract says. And the closing date is irrelevant. The contract is very specific. Dated as of January 25th, 2018. Signature lines. In witness whereof, the parties have executed this agreement effective as of the date first set forth above, January 25th, 2018. So what Mr. Dunoff may have told Mr. Villari in the evening of January 31st after the closing about negative assets on Ameris's books and records is not material. It's disputed when Mr. Villari knew, and it was disputed in the arbitration, and the arbitrator did not hold that Mr. Villari knew. He said what was in that holding was he knew at least as early as January 31st, and they had good cause to terminate because she should have told him at least then. That's all that holding says. It doesn't say he knew, he participated, he was involved, nothing. He should have told them on January 31st, 2018 when he found out. That was it. Nothing about all this other stuff about, what he knew, whether anybody knew. All of that stuff about what everybody knew was disputed. When they knew it, there's evidence in the arbitration that Mr. Villari said, is there a problem? No response from Mr. Granite. Is there a problem? No response from Mr. Granite. And finally, everything's okay. That was the evidence. But again, not relevant or material to what the status of holdings was on January 25th, 2018. So again, they want to take this broad, expansive view of adverse effect, but 5.5 limits it specifically to not whether anything Mr. Villari knows or did unrelated to holdings would have an adverse effect on Mr. Villari, but on holdings, in relationship to his ownership of holdings. And the answer is no. And they haven't produced anything about holdings, only about Ameris. And that's not what they asked for and not what they got. So unless you have any further questions, Your Honor, I think we've covered this pretty extensively. And again, I want to point out that all the loans we're talking about, and we've put this in our brief, there are 6 loans that they are claiming as damages in this case that were originated by Brand and purchased by Ameris in 2016. And there was a due diligence process in that purchase. And the time to get indemnified by Brand has passed. So now they're trying to get Mr. Villari to be responsible for their purchase of these loans. And that's not what the purpose of the SPA is. Thank you.
All right. Two major issues, whether Mr. Villari and in effect the trust had prior knowledge of these bad loans and whether these bad loans constitutes an adverse effect as to pertaining to the holding company. As to the awareness, I think there is some evidence in the record that Mr. Villari did not know at the time of the effective date of the stock purchase agreement. And there is also some circumstantial evidence that he did know. That's clearly a question of fact, and it's a question of fact that would need to be resolved by the fact finder. The tougher question is whether this is an adverse this constitutes an adverse effect on USPF. And while I understand that the relationship between the loans and Ameris Bank's ownership and the holding company, that there are a series of leaps, and it may not be an entirely direct relationship, there is at least some evidence in the record that bad loans that are being held by Ameris or managed by Villari, or the intellectual property being licensed through the holding company, there is some evidence that those bad loans can have an impact on the value of the holding company. There is evidence that the parties considered that. And I understand and I appreciate Mr. Kushner's argument that it could have been written into the agreement specifically. But that doesn't mean it doesn't fall into the broader language of the agreement that talks about any adverse condition in the financial circumstances of the company. So I think it's going to be, it's going to be a task, and it's going to be a difficult task to prove actual harm in dollars to the holding company. But I think that the plaintiffs have the right to go to the jury and present that evidence, or go to the fact finder and present that evidence, see if they can prove that this did indeed cause harm to the holding company, and that Mr. Villari was aware that it would be harmful to the holding company. There's a lot to unpack in there, and I don't think it's resolved or precluded simply by the language of the agreement. So the motion for summary judgment is denied. Say to Mr. Thomas, if you'd like to submit a proposed order on the motion, to share it with your co-counsel. And if you all can agree at least as to form, not as to substance, then send it on to Mr. Townsend, and we'll get it entered. Any questions or any additional issues we need to take up at this time?
I don't think so.
Has there been, and you forgive me if this is in the record and I just didn't see it, have there been any settlement discussions? Has there been any talk of trying to mediate this, or is it just too tangled up with multiple litigation on multiple fronts to be susceptible to that kind of resolution?
Mr. Razi and I have spoken many times over the last several years about somehow resolving all of the issues, and unfortunately I think they're all too tightly packed together to separate out some of these issues. Happy to continue those discussions, but while the parties literally detest each other, counsel has gotten along fine. Mr. Razi and I, Mr. Tate and Mr. Thomas came into some of the other stuff after the arbitration, but Mr. Razi and I have a fine relationship and talk periodically about sort of the big picture issues, and no problem obviously continuing that. We just haven't been able to sort of unpack them all or figure out a way to resolve pieces of the pie as opposed to the whole pie. Right. I think that's accurate, Ben.
Yeah, I would second that. I think, hope springs eternal, and there's an open channel of communication. And, you know, we've all seen more intractable things ultimately get resolved. So, but I agree, nothing's imminent.
Well, it's good to know that y'all have open lines of communication, so it won't be the lawyers that get in the way of this happening if it's going to happen. But we've all dealt with difficult clients who do not get along with each other, and that's partly what keeps us all in business. And you know, just another thought, if there was ever a case perhaps for a national business court, this might be it, where you could just have one judge or maybe even a panel of judges that hears everything and understands all the ins and outs of the relationship and can rule on things from that perspective, because I'm just seeing, you know, really for the first time, this slice of it. I can't pretend to understand all of it, but, you know, I'll deal with what is the best I can with the issues I have in front of me.
We appreciate you. I know I speak for all the parties, Judge, but we appreciate you digging into it, and pleasure to meet you by Zoom.
One day we will be together again. I have been in person with Mr. Tate before. I've been in person with Mr. Kushner before. Mr. Thomas, you look familiar, although I can't say for sure that I've seen you in person.
I believe this is my first time.
All right. So if there's no other business, we'll get the order entered and we'll go from there. I wouldn't be surprised if somebody asked for a certificate of immediate review, but we'll cross that bridge if and when we come to it.
Thank you, Your Honor.
All right, everybody have a great weekend.
Thank you. Thanks all.
All right.